Among other things, he wants to stop people from making their own guns. But look, Americans have been doing that for centuries. And
the Conservative majority backs those two men.
The decision was issued in October, and I knew, because of the composition of the court, the decision that was rendered today was going to happen.
The same device a gunman used to kill 58 people at a Las Vegas concert back in 2017.
The decision strikes down a New York firearms law and restrictions.
The Supreme Court now is controlled by conservative judges.
And just to go in everyone's home in the United States and grab a particular product.
Significant Second Amendment news from the U.S. Court of Appeals for the Fourth Circuit involving Maryland. The court ruled 2-1 that the state's particular regulations regarding the acquisition of handguns are unconstitutional, and Maryland effectively acknowledged this. This is significant because the Fourth Circuit case has established numerous precedents. Arm control measures in 2 states. In the wake of a landmark U.S. Supreme Court decision last year that significantly limits what the government can do to restrict arms, states led by Democrats have scrambled to circumvent or test the limits of the ruling. A few have approved new arm restrictions. Oregon even passed a ballot initiative to ban high-capacity ammunition mags. But this week, supporters of the new arm measures suffered a pair of setbacks, underscoring the rippling effect of the court's decision. A 3-judge panel of the U.S. Court of Appeals for the Fourth Circuit in Richmond, Virginia, ruled that a 10-year-old Maryland law related to licensing requirements for handguns was unconstitutional. On the same day, a state judge in southeastern Oregon concluded that a ballot initiative approved by voters in 2022 that would prohibit high-capacity mags and require background checks and training to obtain arm permits violated the state constitution. For the Arm Owners of America, a lobbying group in Virginia that has been active in litigation, the twin rulings merited a news alert distributed to its members, heralding good news for arm rights supporters to celebrate this Thanksgiving. In an email, Eric Pratt, the group's senior vice president, said he was thrilled by the ruling in Oregon and found the Maryland one just as encouraging. At the end of the day, more and more Americans are realizing the government cannot be trusted with their safety, Mr. Pratt said, citing a new poll from NBC News showing that arm ownership has been rising to record levels.
An anti-rights party. They're power hungry. They want to pack the courts, and they're trying to ban our guns.
Nobody can seriously argue that you have to have this kind of a weapon for self-defense.
Among other things, he wants to stop people from making their own guns. But look, Americans have been doing that for centuries. And
today, a federal court struck down a controversial Maryland gun law. The law required people to obtain a special license before buying a handgun.
Also, this bill was written with constitutionality in mind, so I definitely had a good feeling.
Freedom that's guaranteed under the Second Amendment. That language says that the right to keep and bear arms shall not be infringed.
I expect that these critical regulations will be finalized.
Legal scholars were more circumspect about what the latest rulings portended, noting that other recent court decisions, such as in Illinois, and arguments in a new arm case before the Supreme Court, suggested that there was still some momentum for armed crime prevention laws. Still, they said that this week's decisions reinforced an unmistakable trend in which judges, especially ones appointed by Republican presidents, were interpreting the Second Amendment as broadly as possible. It's part of the zeitgeist of the courts, saying that we should take the right to keep and bear arms more seriously than we have been, said Jacob D. Charles, a law professor at Pepperdine University who has tracked arm regulations and court decisions. There have been examples over the last year and a half where lower court rulings have been repeatedly and significantly been reading the Second Amendment pretty expansively and striking down laws that were never thought to be unconstitutional before Bruin. Bruin refers to the Supreme Court case New York State Rifle and Pistol Association versus Bruin, which has quickly become the shorthand reference for the battle over arm control, in much the way that Dobbs and Roe have become shorthand in the abortion debate. In its 6-3 decision in June 2022, the Supreme Court dramatically shifted the standard for arm restrictions. Writing for the majority, Justice Clarence Thomas asserted that arm laws should be judged not by the long-standing practice of balancing arm rights against public interest, but by the Second Amendment's text and the historical tradition of arm regulation.
and that's now been backed. They have been backed in this ruling by the Supreme Court. It was a majority ruling of 6-3.
There were muskets that were used back then. You didn't have weapons of mass destruction like you have now, automatic rifles.
The Conservative majority backs those two men.
And so the reliance on history is just completely disingenuous. We know that Justice Clarence Thomas...
And basically found that this law is unconstitutional, so they've struck it down. So
it is absolutely shocking that they have taken away our right to have reasonable restrictions.
Since then, lower courts have struggled to hunt down references to obscure or since-forgotten regulations in attempts to assess historical tradition. One federal judge in Indiana likened the assessment of the constitutionality of arm laws to a game of historical Where's Waldo. Earlier this month, the Supreme Court's conservative majority appeared willing during oral arguments to consider narrowing the scope of the Bruen case in a new case, United States versus Rahimi, and uphold a federal law disarming domestic abusers. The aftermath of Bruen has also prompted a surge in lawsuits challenging various arm laws, according to Giffords, an armed control group with more than 450 decisions trying to interpret the case. The new laws now being litigated in the courts take various forms. New York, for instance, passed a law trying to prevent people from carrying arms in sensitive locations like Times Square, public transit, sports venues, and houses of worship. The law has created confusion and generated numerous lawsuits. Illinois banned high-power arms in January as a response to a mass slaying on July 4, 2022 in Highland Park. This month, the U.S. Court of Appeals for the Seventh Circuit, based in Chicago, upheld that ban. Preliminary research indicates that judges appointed by Republicans are far more likely to strike down arm regulation laws after Bruen, said one of the paper's authors, Eric Rubin, a law professor at Southern Methodist University. Such was the case this week with Maryland, as the federal appellate court split 2-1 with an appointee of former President Donald Trump writing the majority opinion.
Yes, but I would also add that this case has been happening at the Supreme Court for some while now.
But Justice Thomas, who's the most fervent advocate of the Second Amendment, was looking for this opportunity to pass this law.
What happened in Uvalde before the mass shooting in Buffalo as well.
I've been warning our state since October because I have followed the decision.
By leaders at state level, already New York officials are worried about what this means next.
The decision was issued in October, and I knew, because of the composition of the court, the decision that was rendered today was going to happen.
Your right to own a gun can also be restricted.
In a statement, Randy Kozik, executive director of the Institute for Legislative Action at the National Rifle Association, said, "The Fourth Circuit Court's decision to overturn Maryland's restrictive arm license law sends a clear message. Law-abiding Marylanders' fundamental right to self-defense must not be infringed." Oregon was different, because it was the state constitution, not the Second Amendment, at stake. But in rural Harney County, where almost 85% of voters said no to the ballot initiative imposing new permit requirements and banning high-capacity mags, Judge Robert S. Raccio concluded that some of the alarm over arm ownership was misplaced. While mass slayings have a significant impact on the psyche of America, they actually rank very low in frequency and are sensationalized by the media, he said in his ruling. In a statement, Oregon's Attorney General Ellen Rosenblum, a Democrat, pledged to file an appeal and expressed confidence that the state would win. The case could ultimately be heard by a state Supreme Court whose 7 members have all been appointed by a Democratic governor. Eric Tershwell, executive director and chief litigation counsel of Everytown Law, described the post-Bruen period as akin to a game of ping-pong, where one day one side wins, the next day the other wins, and what we need is additional clarity from the Supreme Court. He added, "You can look at the last 2 days and say, yes, there are 2 decisions that are unfortunate and wrong-headed that are likely to be reversed. If you zoom out to the last 30 days or so, there's been some very positive signals for armed safety and armed safety laws." Arms and domestic crime protection orders. The court has accepted several cases relating to the Second Amendment this year. Perhaps the most impactful of the group is United States versus Rahimi. At issue is whether 18 U.S.C. 922 G8, which prohibits the possession of arms by persons subject to domestic crime restraining orders, violates the Second Amendment on its face. The justices heard oral arguments fire a shot after seeing a bystander. Rahimi called CM after the incident and threatened to shoot her if she told anyone about the abuse. A few months later, Texas issued a domestic crime restraining order against Rahimi. While that order was still effective, he became a suspect in a series of incidents. Upon searching Rahimi's home, police found arms and ammunition. Rahimi pleaded guilty to violating a federal ban on the possession of an arm while he was the subject of a domestic crime restraining order pursuant to 18 U.S.C. 922 G8, a felony with significant prison time. The Fifth U.S. Circuit Court of Appeals initially upheld his conviction. After the Supreme Court in New York State Rifle and Pistol Association Inc. v. Bruin struck down New York's proper cause requirement because it ran afoul of the 14th Amendment by violating law-abiding citizens' Second Amendment rights, the Fifth Circuit withdrew its former opinion and issued a new opinion vacating Rahimi's conviction. Under the Bruin standard, courts must determine whether the Second Amendment's plain text covers an individual's conduct. If so, then the Constitution presumptively protects that conduct, and the government must justify its regulation by demonstrating that it is consistent with the nation's historical tradition of arm regulation.
The Second Amendment to the United States Constitution, Mr. President, as you well know.
Bad as that is, it's the way that they're doing it, Perry. President Biden is circumventing the Congress.
That this bill would ban weapons that are in common use in the United States today.
Those are accessories to semi-automatic rifles that increase the rate of fire.
A ruling that today was upheld when the Supreme Court declined to hear two cases challenging the ban.
It is preventing the next mass shooting, and it is critical to cut off the easy access to these weapons of war.
Banning activity really that's been legal since before our Constitution was adopted.
The Fifth Circuit reasoned that Rahimi was still only a suspect in the additional incidents, and the domestic crime restraining order was not a conviction, but rather an order pursuant to a civil proceeding. It determined that the federal statute impermissibly infringed upon Rahimi's Second Amendment rights and that his conviction must be thrown out. Rahimi argues that the federal statute metes out severe punishment against conduct expressly protected by the Second Amendment, the right to bear arms. He further argues that there is no tradition to the country's history to remove arm from individuals involved in a domestic crime incident. The government argues that no violation of the Second Amendment occurs when a court finds a person poses a credible threat of domestic crime and should therefore be temporarily prohibited from possessing arms. 25 states, Washington, D.C., and the Northern Mariana Islands filed as amici in this case. They argue that the court should reverse the Fifth Circuit's ruling and reaffirm that states can and should be able to regulate arm ownership by dangerous individuals, pursuant to their interest in providing for the health, safety, and welfare of their citizens. They further argue that a ruling for Rahimi would undermine the state's public safety objective of protecting their citizens from domestic crime. Arm issues and the First Amendment. National Rifle Association versus Vullo will address whether Maria Vullo, a former superintendent of the New York State Department of Financial Services, violated the NRA's First Amendment rights. After the Parkland, Florida mass slaying, many companies chose to disassociate themselves with the NRA and NRA-endorsed insurance products. The department issued non-binding guidance memoranda to banks and insurance companies, encouraging them to monitor their risks, including reputational risks that may arise from doing business with the NRA. The NRA claims that the guidance memos constituted regulatory threats that resulted in the NRA being dropped by its long-standing corporate insurance carrier. The Second U.S. Circuit Court of Appeals ruled in favor of Vullo and held that while they cannot use their status to coerce people or other entities from refraining from protected speech, government officials have a duty to address issues of public concern. The Second Circuit then ruled that the NRA failed to show that Vullo had crossed a line between attempts to convince and attempts to coerce. This case could affect how state government employees, in their professional capacity, discuss controversial issues such as arm control. arms and the Chevron deference. In Garland versus Cargill, a case from the 5th U.S. Circuit Court of Appeals, the court will determine the legality under federal law of bump stocks, gun stocks that make use of recoil to allow semi-auto arm to fire like automatics. The case arises from the 2017 Las Vegas mass slaying, in which the perpetrator used an arm modified with bump stocks to slay 61 people and wound over 400 more in 10 minutes.
Since the 2017 mass shooting at that music festival in Las Vegas,
call on the United States Congress to ban rifles like the one used by the sick perpetrator of this mass killing.
the Supreme Court has rejected an effort from gun rights advocates to challenge the ban on what are called bump stocks.
Gun violence does not discriminate. It happens everywhere and all the time.
This is the same device a gunman used to kill 58 people at a Las Vegas concert back in 2017.
Las Vegas was terrible, but to do a knee-jerk reaction.
Today's decision, which gun safety advocates are declaring a big victory.
Under the Arm Owners Protection Act of 1986, it is illegal to own a mash gun, but due to the ambiguity of the statute, there are conflicting views on whether semi-auto arms, modified with bump stocks, are covered by the ban. The Trump administration's Department of Justice issued a final rule stating that bump stocks are covered by the mash gun ban. Under the so-called Chevron doctrine, the latitude federal judges give agencies over how to interpret a statute when a dispute arises, the court would be required to defer to the DOJ's rule, but the court intends to re-examine Chevron this term. If Chevron is overruled, the court would have the ability to veto the rule and effectively legalize bump stocks.
By the way, bump stocks, we're writing that out. I'm writing that out myself.
On the weapons ban. This morning, the court ruled the ban is constitutional.
Supreme Court will consider a challenge to a Trump-era ban on so-called bump stocks.
This administration issued a ban on bump stocks, a ruling that ever since has been challenged by gun right advocates.
To propose regulations to ban all devices that turn legal weapons into machine guns.
The new case will decide whether the ban violated a federal law by changing the bump stock.
Now, owners of bump stocks are required to destroy the devices or turn them into federal authorities.
There are currently 2 related cases pending certiorari. Geddes versus Bureau of Alcohol, Tobacco, Firearm and Explosives, and Garland versus Hardin. Both concern the legality of bump stock devices. If the court grants review to either of these cases, they will likely be heard in tandem with Cargill. Limits of arms rights. The Supreme Court is taking up a challenge to a federal law that prohibits people from having arms if they are under a court order to stay away from their spouse, partner, or other family members. The justices are hearing arguments Tuesday in their first case about arms since last year's decision that called into question numerous arm control laws. The Federal Appeals Court in New Orleans struck down the law following the Supreme Court's Bruin decision in June 2022. That high court ruling not only expanded Americans' arm rights under the Constitution, but also changed the way courts are supposed to evaluate restrictions on firearms.
Place in New York where basically if you want to carry a concealed weapon, you need to apply for a permit, but then you need to justify it.
The Supreme Court now is controlled by conservative judges.
The U.S. Supreme Court in the last couple of hours, which has ruled that Americans do have a fundamental right to carry firearms in public. The decision strikes down a New York firearms law and restrictions.
This is a huge victory for pro-guns advocates. So this centres around a century-old law that's...
We have now restrictions on who can purchase a gun.
It's about people being able to protect themselves against a tyrannical government.
Justice Clarence Thomas's opinion for the court tossed out the balancing test judges had long used to decide whether arm laws were constitutional. Rather than consider whether a law enhances public safety, judges should only weigh whether it fits into the nation's history of arm regulation, Thomas wrote.
We passed one particular bill that was mine that controls the use of ghost guns. Now, anyone can basically purchase a concealed weapon and carry it around New York State.
The Second Amendment is not about duck hunting, right?
You need to give a special reason for why you need to carry that gun.
And when you have these, despite us having these restrictive laws, and a lot of the laws that we pass deal with automatic rifles.
The Bruin decision has resulted in lower court rulings striking down more than a dozen laws. Those include age restrictions, bans on homemade ghost arms, and prohibitions on arm ownership for people convicted of non-violent felonies or using illegal drugs. The court's decision in the new case could have widespread ripple effects, including in the high-profile prosecution of Hunter Biden. The president's son has been charged with buying an arm while he was addicted to drugs, but his lawyers have indicated they will challenge the indictment as invalid following the Bruen decision. The outcome probably will come down to the votes of Chief Justice John Roberts and Justice Brett Kavanaugh. They were part of the 6-justice conservative majority in Bruen, but Kavanaugh wrote separately, joined by Roberts, to underscore that not every arm restriction is unconstitutional. The case before the court involves Zaki Rahimi, who lived near Fort Worth, Texas. Rahimi hit his girlfriend during an argument in a parking lot and then fired an arm at a witness in December 2019, according to court papers. Later, Rahimi called the girlfriend and threatened to shoot her if she told anyone about the assault, the Justice Department wrote in its Supreme Court brief. The girlfriend obtained a protective order against him in Tarrant County in February 2020. 11 months later, Rahimi was a suspect in additional incidents when police searched his apartment and found arms. He eventually pleaded guilty to violating federal law. The appeals court overturned that conviction when it struck down the law. The Supreme Court agreed to hear the Biden administration's appeal.
From the governor of New York, who's described this decision as a dark day.
And that's why Biden's regulations are such dangerous infringements.
And just to go in everyone's home in the United States and grab a particular product.
They're not going to do anything to stop criminals from getting guns, but they will make us less safe.
Comes just months after the Supreme Court voted to expand gun possession rights.
Just because a person might have used that product is not the American way.
To protect America's new gun safety laws, but that's yet to go anywhere. We've yet to see a vote on that.
Rahimi remains jailed in Texas, where he faces other criminal charges. In a letter he wrote from jail last summer, after the Supreme Court agreed to hear his case, Rahimi said he would stay away from all arms and weapons once he's released. The New York Times first reported the existence of the letter. Arms were used in 57% of slayings of spouses, intimate partners, children, or relatives in 2020, according to data from the Federal Centers for Disease Control and Prevention. 70 women a month on average are shot and slayed by intimate partners, according to the Arm Control Group, Every Town for Arm Safety. Overturning Maryland's stringent hand-arm licensing requirement. This is the U.S. Federal Court, the United States Court of Appeals for the Fourth Circuit out of Maryland, in a case entitled Maryland Shall Issue and Firearm Policy Coalition, an Independence Institute versus a whole host of, government officials in the state of Maryland. And there's some other plaintiffs as well. Of course, congratulations to all of the plaintiffs in this case, a major win for the Second Amendment. This is a decision from Judge Richardson. He writes, if you live in Maryland and you want a handgun, you must follow a long and winding path to get one. Like with any arm transfer, whether a purchase from a licensed dealer, arm to a private person, or even a gift from a family member or friend, you must comply with Maryland's 77R registration process, which requires you to fill out an application with certain identifying information and then wait 7 days while the state performs a background check. And if you want to carry your handgun, you need a separate carry permit as well. But as Judge Richardson and the Fourth Circuit continued onwards, but for hand arms specifically, before you do any of that, there's an additional preliminary step. You must also obtain a hand arm qualification license.
Criminalizes gun ownership. And nothing has happened except violent crime has spiraled out of control.
Maryland passed a handgun licensing law. Among other things, it required people to submit fingerprints for background.
Court has ordered the state to stop enforcing this law immediately.
Take a firearm safety course, and then wait up to 30 days to get this license.
So far, the state has not indicated whether it plans to appeal.
It's the group Maryland Shall Issue challenged the law in court in 2016, calling it unconstitutional.
And getting that license requires, among other things, submitting fingerprints to undergo a background investigation and taking a 4-hour-long arms safety training course in which you must fire at least one live round. Then, after submitting your application for this extra license, you must wait up to 30 days for approval before you can start the rest of the process. Plaintiffs seek to enjoin the state from enforcing only this additional preliminary hand-arm license requirement, and plaintiffs' challenge must succeed. It must succeed. Landarm's Second Amendment victory in the Fourth Circuit. The challenge statute limits the capacity of the law prohibiting adult citizens from carrying arms, and the state has not shown any historical precedent to support this limitation. Indeed, it appears that Maryland has acknowledged that it was unable to locate one. As a result, under the Supreme Court's new burdens shifting test, these claims that Maryland is a particular Maryland law fail, and we must enjoin its enforcement. This means that we reverse the district court's contrary conclusion, marking a significant victory for the Second Amendment over Maryland.
The U.S. Supreme Court expanding gun rights by striking down a New York law
with a 15-round limit for handguns. This morning, we're hearing from people on both sides of the issue.
Supreme Court in the last couple of hours, which has ruled that Americans do have a fundamental right to carry firearms in public.
Today, the United States Supreme Court ruled that people have a right to carry a gun outside of their home.
With legal staff as well as legislative leadership to ready and craft legislation that will be heard next week.
Laws or bills like an age limit or bans on the certain types of guns you're allowed to own.
The concluding paragraph specifically states that in Maryland, law-abiding citizens who desire handarms must wait up to 30 days for the state's approval. Until then, there is nothing you can do because the situation is beyond your control. There may be a tradition of banning dangerous people from owning arms, but under the Second Amendment, mechanism matters, and Maryland has not cited any historical laws that function by presumptively depriving all citizens of arms to keep them out of dangerous hands. Maryland has not demonstrated that this regime is consistent with our nation's historical tradition of arm regulation. Plaintiffs' challenge must succeed, and the lower court's decision to the contrary is not acceptable and fails. Okay, huge win here.
This is a huge victory for pro-guns advocates. So this centers around a century-old law.
Bans dozens of specific types of rifles and handguns, 50 caliber guns, attachments, rapid firing devices.
Do not have to prove a special need for self-defense. So California has a similar law that is now...
This is exactly the kind of dangerous decision we've come to expect from this Supreme Court.
That the NYPD uses to determine if someone is eligible to receive a carry permit is unconstitutional.
The issues will be, of course, will other states follow? There are other states that have similar rules, such as California, Massachusetts.
Now here's some of the key rationale. Here's the interesting thing. First of all, this is in the Fourth Circuit Court of Appeals. This is a terrible circuit for arm rights. Terrible, terrible, terrible circuit. So it is possible if you're the state of Maryland, they're going to seek en banc review here and try to get the Fourth Circuit. A terrible court, a pathetic court when it comes to the Second Amendment. Just pathetic to try to grant en banc review and try to delay this. That is probably what Maryland's going to try to do. We will see what's going on here. Now we will just digress just briefly, which is that, as you know, for those of you following Maryland law, which is a terrible armed state, of course, but it makes Baltimore a perfectly safe community, of course. Well, anyway, we know that earlier this year, months before this decision was argued, as we recall, you had an argument about the Maryland assault weapon ban of Beyond.
While concealed carry laws, also known as CCWs in California, aren't instantly nullified by the appendage.
All gun laws must be consistent with the nation's historical tradition. And Alex,
basically, if you want to carry a concealed weapon, you need to apply for a permit, but then you need to justify it.
But now there is a right to possess a handgun.
This bill was written with constitutionality in mind. It was based on bills in other states where the same ban has been upheld.
Need the gun for self-defense. She said the court broadened gun rights beyond what many experts expected.
Yet no decision has come out involving the Beyond case, so one wonders what's going on there. We've got some speculation, and we'll talk about that in another video. But it does appear as if the attack weapon case involving Maryland and the Fourth Circuit is there some sort of games going on within that court, because it makes no sense for the assault weapon case, which of course is a semi-auto arm weapon ban case, to have been argued months before this case in Maryland shall issue, and yet no decision has been rendered in that case. And by the way, one of the judges in this panel here today was also on the Beyond panel, so there's some games going on in the Fourth Circuit Court of Appeals involving the assault weapon ban, but we will get to that separately. But what is the other great news going on here with this Maryland shall issue victory? And congratulations again on the Independence Institute, to the Armed Policy Coalition, of course, to Maryland shall issue, a great group out of Maryland. Congratulations to all the plaintiffs again, but again with this said, the reason why many people really like this opinion and addition to the result, of course, is there's a lot of precedents that and statements that are made within this opinion that Second Amendment plaintiffs and Second Amendment judges who want to apply the Second Amendment correctly can use.
A new bill the governor calls the strongest Second Amendment legislation in Texas history is awaiting his signature.
So I'm just grateful for the Illinois Supreme Court following along with precedent and doing the right thing.
That was true before the Bruin case. That's what we deal with often in our.
As a dark day, and then gone on to say that it is absolutely shocking that they have taken away our right.
When you have a Supreme Court where the last two justices that were elected.
What we're thinking about places like parks, those have been mentioned.
For example, the argument by Maryland here was that because the right to keep and bear arms was not totally destroyed here because you just had to wait. That was not an infringement under the right of the people to keep and bear arms shall not be infringed. But here the court rejected that notion that only a total destruction of the right implicates the plain text, because as you remember, the plain text is implicated, then the burden shifts to the government to come forth with the historical analogs. A victory for Second Amendment rights. So, if you are a Second Amendment plaintiff, you want a lot of things to implicate the text of the Second Amendment, because that shifts the burden to the government. Once the burden shifts to the government, as we see in this case, the government simply basically cannot win any major arm control laws or uphold them in modern-day American life. That's because there were very few arm control laws in 1791 when the Second Amendment was adopted, which makes a whole lot of sense if you think about it. Why would you adopt a fundamental right to keep and bear arms in the Bill of Rights itself, while at the same time pretending that the state and other parts of the country thought this was not a right?
People to carry a handgun without a permit.
Yeah, and there are a lot of lingering questions about the rules
that would allow adults to legally carry a handgun without training. This comes some 2 years after lawmakers passed.
There is no other right where we require individuals to show a need in order to be able to exercise that right.
This does not change, again, where you can carry, what you can carry. It eliminates the requirement.
From the governor, it's really hard to be realistic.
You still have to apply for
They basically said that law-abiding citizens who are not dangerous at all had to wait for government approval up to 30 days in Maryland before they could acquire a handgun, and there's simply no historical analog supporting this.
PD has unveiled emergency rules that will let people carry concealed weapons in the city.
The decision strikes down a New York firearms law and restrictions
that required a person to show a special need in order to get a permit to carry a gun in public.
Is that the police department is going to have to supplement this rule with some clearer description.
And that's now been backed. They have been backed in this ruling by the Supreme Court.
Prior to this decision, we had the ability to issue or not issue based upon our criteria.
This is very good news, because in a lot of these states like Maryland, New York, and New Jersey, there are these long delays involving getting a hand-arm permit and a carry permit. This is a powerful precedent that goes to the point that there is simply no basis for delay, because it's inconvenient for the government, and the government wants to take that extra time to do their work because they're lazy, sloppy, or inefficient, or all of the above. So again, a powerful precedent is that a delay is indeed an infringement because it hinders the right to keep and bear arms, especially if you don't already have a gun. Specifically, the court rejected analogous laws that prohibit dangerous individuals from owning arms, reasoning that while the Maryland law applies to everyone in the state, it is not specific to dangerous individuals.
Bill that's HB 189, and it would allow anyone over the age of 18 to be able to carry concealed without a permit.
The GOP-backed bill will no longer require individuals to get a permit from the state to own a gun.
They're going to have to show that there weren't other less restrictive manners.
But I want you to know, we have been anticipating this moment. We have not been sitting by passively. We've been working closely with our Attorney General.
There are ways that we can maintain the Second Amendment, continue to give them the rights.
Challenges against them are now more likely to succeed in court.
All American citizens in Maryland have to get pre-approval, and there's simply no historical analog for everyone in a state to have to get pre-approved to get a handgun. Maybe dangerous people could be restricted after they're found to be dangerous, given due process and so on. But for ordinary people that have not been found to be violently dangerous, those rules simply don't apply. The state tried to rely on militia service laws about certain requirements associated with serving in the militia. But here, the Fourth Circuit made the right point that says, hey, militia training laws involve people that are in the militia. They don't apply to everyone in America that had an arm. So if you own arms and you were over the age of 45, or you own arms and you were a woman or whatever the reality is, those militia training laws didn't apply to everyone in the state or everyone in the country. They only applied to people that were in the militia and had obligations to the militia, not to all arm owners in the country. Therefore, they said that's not a proper analog to use militia service laws or militia requirements as a basis for forcing everyone to go through this pre-hand-arm acquisition background check and process.
This is also preparing for potential lawsuits if permits are not issued from organizations like Dudley Brown's.
That's expedited. You just produce the permit and you don't have to go through the whole background check.
But with those rights come responsibilities, and we should have responsible gun laws to keep ourselves safe.
Reasonable restrictions, so immediate reaction from the New York governor, but
Don't have the bill in writing yet, as they're still trying to format it in coordination with the Bruin case.
Just expect everyone to have a gun. Now the question of whether a good guy with a gun.
Among the advantages is you will still have to go through a federal background check to purchase a weapon.
Go into effect September 1st. People who were recently rejected because of the current statute.
The last thing that's very important is we know that Section 3 of the Heller decision that talks about Heller is not designed for getting rid of long-standing rules about felons in possession and so on. But as you know, that language is what we've said before is dicta. It's not binding on anyone. It's just dicta. And yet the anti-arm lawyers and the anti-arm judges like to view that as the one aspect of Heller they view as inviolate law, that they can do anything they want. Of course, that's not true. They ignore the rest of the pro-Second Amendment discussions and focus on a very few specific exceptions. But the good news is this Fourth Circuit decision specifically rejected any reliance on the Bruin footnote dealing with shall issue licensing, and basically said that language and related language is really just dicta. It was not any official finding or ruling or holding by the Supreme Court. Therefore, they concluded they had to do their analysis, which they did, and concluded there's simply no historical analogs to justify this Maryland law. So again, to close, the court said that forcing people to go through that 30-day-long process and everything else is a hindrance to the right to keep and bear arms, because it delays your ability to get an arm to be able to protect yourself, among other things.
The bill now goes to the Senate, where its future is unclear. The chamber refused to take up a similar proposal.
Gun crimes in New York are committed by people who do not have gun permits at all.
Watching this around the world, perhaps may be surprised after all of those events we saw in.
Legislators told me they're going to have a hearing on Tuesday to discuss the new legislation, like potential gun-free zones.
All it's going to take is a few court cases, and they're going to have to issue permits.
Even with this new law, it doesn't mean anybody can carry any gun anywhere, anytime.
CBS 2's Alicia Reed here now with the new guidelines and what it means for gun owners.
That did constitute a hindrance that triggered the text of the Second Amendment, and once that occurred, the burden shifted to the government. The court ruled that Maryland's only analogies dealt with dangerous militia members, and that they did not justify making the entire state of Maryland go through this process. As a result, the procedure cannot uphold the nation's long-standing tradition of regulating arms and is therefore deemed unconstitutional under the Second Amendment, the Bruin Standard, and of course the Heller Standard. That's all for this video, folks. See you next time.